Following program is paid for by Vastola Legal. The views and opinions expressed in this content do not reflect those of 850 WFTL.
Hey, we know it's early. But what better way to start your day than by getting free legal advice? This is Vastola on the Law with your host, Attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
Well, good morning, everybody. May God bless you, and thank you for tuning in to Vastola on the Law. I am Jeff Vastola. I'll be with you for the next 30 minutes or so to give you free legal advice. If you'd like to call in with a question of your own, please do that. You just heard the number. It's 877-850-8585. If you'd like to just sit back and relax and soak it all in, be my guest. I'm here just about every Sunday morning live to give you free legal advice. Spread the word. If you know somebody that's embroiled in a lawsuit and they just don't know what to do, or if you're having some kind of a conflict and you'd prefer to find out how to resolve this amicably, that's really what I'm all about. Even though I am a trial lawyer, I do try to avoid disputes, believe it or not. And I do try to avoid the courthouse, believe it or not. So, a little bit about me, just in case you're interested. I've been a trial lawyer for over 23 years now. I have a couple of brick and mortar offices. I have one up in Stewart on US 1, and I have one in Palm Beach Gardens in the Carmine's Plaza. So you can make an appointment to come see me in person and sit down face to face if you'd like to talk with me about a case that you think you may have. Now, I don't do everything. What I handle Monday through Friday are personal injury, wrongful death, product liability, medical malpractice, those types of claims that result in injury or a wrongful death of a person, and venturing into a new area for me, and that is sports and entertainment law. It's essentially representation of an athlete and contract review. Obviously, contract review and negotiation being a big part of that. As a trial lawyer, I did a lot of what we call commercial litigation work for probably the first 15 years of my career, and was involved constantly in contract interpretation, sometimes contract negotiation for various reasons, and kind of an opportunity fell in my lap, and so here we are. I'll be hopefully venturing into the area of sports and entertainment law and sharpening my knife, so to speak, in that area. If you have any questions about any of those areas and you'd like to talk to me about a case, you can use my toll-free number, which is not the radio station's number. I have a toll-free number that is forwarded to my cell phone 24/7, and that number is 833-VASTOLA, my last name, V as in Victor, ASTOLA. Numerically, that's 877-827-8652. So if you have anything that you'd like to talk to me about as far as potentially hiring me, not, of course, required to hire me, but if you'd like to interview me, then that's the number to call, and I'll be happy to talk to you. I want to thank those that called in during the week. I've been imploring people to call the show because I think the show is a little more dynamic and more interesting when people call into the show with their own questions, and it's been a little quiet. Of course, we got Dave from last week, and I'm going to be touching on Dave's topic today as my topic of the day. So thank you, Dave. But I got some phone calls during the week to say, look, we listen. We know it's been quiet, but, folks like us just don't have anything to call in and talk about. So don't think that people aren't listening. And I appreciate that because sometimes I wonder. Today's topic of the day was brought to you by David from last week. If you are a regular listener, you will know already that David called in with questions about a patent. Specifically, his question was, essentially, can I appropriate an existing patent because I've come up with a new use? Well, the answer is yes. Keep you off the edge of your seat. The answer is yes, potentially. But I'm going to get into the details of that because I've done some research into not just patent, but intellectual property law. And we'll give you guys an overview of that today. If I have time, I intend to talk about, I want to do a case law update every once in a while. I've been reviewing my Florida Law Weeklies as they come in. And if I have the time, I want to just talk about a selected case every week. And so the case that I've picked out to discuss today is a family law case called Hutchinson versus Hutchinson. And I'll talk to you guys about the facts of that case. And that syncs very well with an individual that I've been communicating with in my social media platform who reached out to me to talk about a issue. Now, of course, I had to tell her I don't do family law. I can't help you other than to give you some advice. But that case proved to be somewhat helpful in giving her some advice because it's a brand new case that just came out. It's in another jurisdiction, but it's still persuasive authority here in the 4th DCA, which is my listening audience, unless you're listening online. Hey, that brings up a good point. If you love this show and you can't do without it, but you're going to go away on vacation, you can listen to this show online live. All you have to do is go to the radio station's website, 850 WFTL, click on Listen Live, or whatever their button is, but it should be pretty obvious right there on the main page. And whatever they're streaming at the given time, you can listen live. And so if you're out west skiing and you want to wake up super early to get some free legal advice, you can do it. You can even call in. You can call in on the toll-free number and participate in the show, even though you're not here in this listening audience, which is Palm Beach County, Broward County, and the Treasure Coast. If you'd like to call into the radio show this morning because you've got a question and it's just it's a burning hot topic for you, 877-850-8585 is the number for you to call in. Before I jump into my topics, just one last thing that I want to do, and I want to try to make this a weekly routine if I can remember to do it, is I want to give a shout-out thank you to someone that helped me during the week. These are non-solicited, they're unpaid for, and frankly, Jim doesn't even know that I'm doing it, but Jim at Tequesta Tire, thank you so much for what you did for me and my family. If you guys need tires or basic auto services, you can go see Jim at Tequesta Tire and Auto, and obviously they're in Tequesta, and you can find them on the internet. But Jim, we appreciate it. We appreciate you, so we hope you have a great week. All right, so I'm going to jump into my topics. Remember, if you want to call into the show, interrupt me, because I'm not going to stop talking for any extensive length of time. I might take a break to take a breath, but don't think that you're being rude because you call me while I'm in the middle of something, because essentially I'm going to be in the middle of something for the entire program. 877-850-8585 is the number to call in if you'd like. Let me get into these intellectual property issues. I've got a couple screens going. I'm just trying to find where I have it. Okay, so this is taken from the U.S. Patent and Trademark Office website. All right, so I don't bury myself in the library for 20 hours during the week trying to find information in old dusty books. This is information that's readily available, not just to me, but to all of you. So I may be simply regurgitating information that you're already aware of, but you certainly have access to all of the same information. The U.S. Patent and Trademark Office, the USPTO, is found at uspto.org. That's the official website for the government. And all of this information is there. But the category of intellectual property is the very broad category that encompasses patents. And there's a couple different types of patent. You can have a utility patent, which is essentially a new invention, some kind of an invention. You can have a design patent, which is, they consider those to be ornamental designs. They're non-functional. It's not like a thing. It's just a new design. And the examples they give here on this website are a unique shape of an electric guitar or a new design of a lamp. So that's a design patent. Now, shifting gears, another form of intellectual property is copyright. These are things that are often written, including things like computer programs, but it can also be things like photographs. It can be music, and it can be fine art, of course. So a painting can also be a form of copyright. So the protection lasts, let me go back to a utility patent, 20 years from the date of the filing of the regular patent application. That's 20 years for the utility patent. The design patent is 14 years. Copyright, this is interesting. The life of the author plus an additional 70 years at least, sometimes 95, from the first publication. So, I'm sorry, I read that wrong. It's the life of the author plus 70 years. This is for copyright. For some works, it's 95 years from the first publication. Now, I don't know what the distinction is, why one would take over precedence over the other, but it seems to me that they're both very lengthy. Another form of intellectual property is trade secret. Maybe the most popular, the most famous trade secret is what? Correct. The Coca-Cola recipe, right? Everybody wonders what that's all about, and everyone thinks that it's buried somewhere in a mountain. The protection of a trade secret lasts as long as the information remains confidential and functions as a trade secret. All right, so if Coca-Cola just were to go out of business and they're no longer producing Coca-Cola, well, then they would no longer have the trade secret for it. They wouldn't need it. But also, if Coca-Cola had a change of heart and said, you know what, we want everyone to be able to produce Coca-Cola and compete with us with our own recipe, here it is. Well, it's no longer a trade secret because they gave it out. And then the last form of intellectual property is trademark, which is something that you can trademark words, symbols, a logo, designs, or slogans, and they identify or distinguish products or services. Again, what's used as an example are Coca-Cola, the Pillsbury Doughboy as a distinctive logo of sorts, a character. And the protection lasts as long as the business continuously uses the trademark in connection with goods or services. When I was doing this very similar radio show, but from a different station about, 10 or 15 years ago, I remember that a case came out. It was a trademark case filed by Madonna because she is who she is. She's made her name incredibly internationally popular. And she sued a jewelry company called Madonna Jewelry, which had been around for a long time. It wasn't somebody that was just trying to jump on her bandwagon and misappropriate her name. But she found out that a business out there had been doing business as Madonna Jewelry, and she filed a lawsuit to shut them down. Now, this is going to be a real cliffhanger because, unfortunately, I don't remember the results of the lawsuit that was filed. I remember back when I was doing the show a number of years ago, it was a hot topic because it had just been filed, and I followed the case, and I remembered the results back then. But I'm going to have to do the research and remind myself of what happened. But it just popped into my head that that's an example of a trademark lawsuit where one person feels as though another business is infringing on their trademark. And it's undeniable that, of course, Madonna has turned her name into an international trademark of sorts, but I can't remember what the outcome of the case was. So I'll look into that, really, maybe just for my own sake, my own curiosity. But so essentially, that's the overview of intellectual property. And of course, David's question from last week really focused on patent only, and I'm sure he meant the utility patent. So what I wanted to do is, in follow-up to David's questions from last week's show, that's the way the show works, by the way. If you ask me a question and I can't give you an educated response as I'm talking with you on the air, then I'll research the issue and I will respond the following week with what I think is an educated response to the question. And oftentimes it will become a topic of the day. And that's exactly what happened with David's question from last week. So, again, giving credit where credit is due. I found an article written by an individual named Kirk Teska off of the NOLO website. And essentially, the article is entitled, "What are Improvement Patents and New Use Patents?" Well, this is precisely what David was asking. He says there's an existing patent out there, and I think it can be used for a different purpose, a new purpose, a purpose other than what it was actually patented. And sure enough, David's not the only one to ever come up with this concept. And the USPTO acknowledges essentially two different categories of where an existing patent can be apparently improved upon or can be used for a new use. So, improvement patents, these are the most common. They include addition inventions. It says an addition invention adds something to what came before. And it gives an example of the Gillette Mach 3 razor. And this causes me to chuckle a little bit because I think it's the Saturday Night Live. It might be some other comedy show, but I thought it was Saturday Night Live that came up with the razor that had 10 blades, because it's just, I guess, a little funny that Gillette went from 2 blades to 3. They patented it, and there might have even been, there's some innuendo here that there might have been some litigation with Schick. I guess maybe Schick had the patent for the 2-blade razor. Well, Gillette invented the 3, and then the Saturday Night Live routine is a razor with 10 blades on it, and it absolutely destroys the guy's face. So I don't know, if you've never seen it, then it's probably not funny to you. But anyway, the Gillette Mach 3 razor is an example of an addition invention because there was an invention out there that had 2 blades, and they said, oh, look, 3's better. A substitution invention. This article gives the example of Amazon's owner or CEO, Jeff Bezos, when he substituted the one-click purchasing feature for the prior virtual shopping cart model. So 2 real-life examples of how improvement patents can be used. So the next, remember I talked about improvement patents or new use patents, and I think that more squarely falls into the category that David was talking about last week. And it says you can also get an improvement patent for an innovation that provides a new use for an existing invention. And again, this is a great article because they don't just tell you how it works, they actually give you an example. Back in 2000, the Federal Circuit allowed a patent for the idea of using bag balm, that's B-A-G, B-A-L-M. Now, just real quick, show of hands, who knows what bag balm was originally used for? And if you're raising your hand, then you must have grown up on a farm. It's an ointment that was normally used to soothe irritated cow udders. I'm not kidding, that's what it says. But somebody found out, and the real head scratcher here is who first tried this. Somebody found out that bag balm could be used to treat human baldness. Right? How do you connect the two? Somebody's going to take an ointment that's used for irritated cow udders and put it on their bald head? I don't know. Maybe they had a rash on their head and they decided, hey, look at this. I can put some cow udder balm on my head. And all of a sudden he had a patch of hair. Maybe that's how it all worked out. So anyway, bag balm is an example of a new use patent because obviously it had been patented for the purpose of soothing an irritated cow udder. But somewhere along the way, somebody learned that it can be used to grow hair. So a new use patent was applied for and granted for bag balm. Now, I don't know if they're using bag balm on a human head under the same trade name. I would suspect that they've probably changed the name. I would hope that they've changed the name. And I don't know what the new name is. And I don't know who owns the new use patent. Maybe it's one of those guys on TV that talks about how they can replace your hair or something like that. But anyway, that's an example of a new use patent. So David, in response to your question of last week, hopefully I've given you some information that you can use to go forward with your new use invention. And again, just an incredible resource for everybody. The USPTO's website, uspto.gov, is really there for beginners. I mean, there are lawyers that specialize in patent and trademark, intellectual property lawyers, and they will use the website for other purposes. But if you're new to patents or trademarks or any other form of intellectual property, and you're trying to figure out how do I go about protecting what I want, what I feel is mine and I need to protect, go to the website. It's really a very user-friendly website, and it will give you a lot of guidance. David, if you have follow-up questions to what I've given you, please feel free to call in. Anybody else, if you have a question of your own or if you have something to add to this topic, please call me at 877-850-8585. Elliot is our board operator today, and he'll take your phone call, put you live on the air with me, and we'll have a good time. If you want to ask me a question about anything else, please feel free to do it. I don't limit questions on this show, obviously, to just what I do day in and day out, and I'm more than happy to field questions of all kinds. I enjoy it. It sounds nerdy, but I didn't mind doing the research on these patents and things, because look what happened along the way. I learned new stuff, and now I know that a cow udder ointment is now being used to treat baldness, and who knows when that might become very helpful. So, not now. Fortunately, I've got a full head of hair right now, but we'll see in the future. If you'd like to call into the show, 877-850-8585. I'm going to switch gears, and I want to talk about let me give my case law update. It's probably a good time to give my case law update. I've got just a few minutes left. Now, this is not in the 4th DCA, this case of Hutchinson versus Hutchinson, and I'm just trying to get to it. So, this is a 1st DCA case, which is up north in the Tallahassee area. But these are ex-spouses, unfortunately, still going through the toiling of a divorce. The husband, they had perhaps a marital settle agreement and a child custody agreement that was in place, and they were getting along quite well, apparently, according to the wording of this opinion. And the wife was allowing visitation that was really over and above what was set forth in the child custody agreement. And as time progressed, things got a little tumultuous, and the wife made a move, and the wife took the child out of the school they agreed upon and put the child in a new school. The child was now further away from the father, not out of the state, but in the county, out further away. And the custody became less frequent, and the husband said, you know what, I've had enough of this, because we were getting along so well. You're not allowed to move without my consent, and here we go. So the husband files a motion to amend the child custody agreement, and he also filed something to modify his support. And the court went through all of the facts, and it was all very specifically presented with evidence about how they were getting along and how the visitation was more than what was set forth. But unfortunately, the court denied the husband's request. The trial court actually granted the husband's request, but then the wife filed the appeal. And these opinions that I read from, these case law updates, are from the appellate courts. It's a court issuing a written opinion on an appellate basis to say, we've considered what happened at the underlying trial court, and we're either going to agree with the underlying court or we're going to disagree. And in this case, the appellate court disagreed, and they reversed. They said the parties' varied time-sharing schedule, the wife's local moves, and the child's change of middle schools does not establish, and this is the key, a substantial change in circumstances sufficient to support a modification of the previous final judgment. And so that is the controlling law in the state of Florida. If you're going to try to modify an existing child custody arrangement, it has to be a substantial change in circumstances sufficient to support a modification. And so if you were to say, okay, Jeff, well, I hear what you're saying, but what's a substantial change? Well, it's a case-by-case basis. There could be 5 different judges in the family law division, and had this been in front of a different judge, the trial court agreed with the husband and said, yes, there was a substantial change. I'm going to modify this. It's the appellate court that looked at everything and said, no, we have to disagree. We're going to reverse that opinion, and we're going to send it back to say that there's not been substantial change. Okay, I just was told that I'm running out of time. Anyway, this is my case law update, Hutchinson versus Hutchinson. And if anybody's interested, I can certainly give you the citation for that. Thank you so much for tuning in. This has been 30 minutes of free legal advice, and I'll be here again next Sunday, I think, unless I'm out of town for one of my daughter's soccer tournaments. But thank you so much for listening. I appreciate it. And remember, the most important thing to have on your automobile insurance policy is uninsured motorist coverage. Had a very good friend of mine call me during the week to say, hey, I'm fully covered. And I went through her auto policy, and lo and behold, she's not fully covered. Fully covered in the state of Florida does not mean that you're fully covered. Make sure you have the optional coverages, and make sure you have uninsured motorist on your policy. If you'd like to talk to me about insurance, a case that you think you may have that you want me to be your lawyer, dial 833-VASTOLA. That's 833-827-8652. And until next week, remember to do the right thing, and may God bless you. Bye-bye.
About the law and the law one. About the law and the...
You've been listening to Vastola on the Law with attorney Jeff Vastola. Turn in next week for more legal advice and answers to your specific questions. You can call Jeff on his cell phone after the show by dialing 833-VASTOLA. That's 833-827-8652.